As a scientist, you are often recording the data of your findings and research. But have you ever stopped to think about your rights if someone else were to use your findings and data without your permission? Let's look at Zandile's scenario. Zandile is currently working on his research into the health benefits of specific compounds in common spices used for cooking. He has compiled comprehensive data on the different spices, their beneficial compounds, as well as how they interact with other spices commonly used together. He presents some of his findings at a conference. In his keynote, he includes tables and diagrams showing the correlation between the benefits of certain spice combinations and their specific bioactive compound interactions. Months later, while continuing his research, he finds his tables and diagrams on a food blogger's site. There is no reference to Zandile being the creator of these tables and diagrams, and the page contains affiliate links and sponsored ads. Zandile seeks advice from his lawyer to determine whether his work is protected by copyright law. Zandile's lawyer informs him that the South African Copyright Act of 1978 provides that for a work to receive copyright protection, it needs to meet the following requirements. 1. It must fall within one of the categories of protectable subject matter. Tables and compilations are protectable as literary works in terms of the Copyright Act. This specifically includes tables and compilations of data stored or embodied in a computer or a medium used in conjunction with a computer. 2. It must be original for the purposes of copyright law. Zandile expended sufficient labor and skill in compiling the data into tables and diagrams, which means he meets the originality standard for copyright protection. It is important to note that a work does not need to be unique or novel to be regarded as original for purposes of copyright protection. 3. It needs to be reduced to a material form. A work is regarded as being reduced to a material form if it is written down, recorded, represented in digital data, or otherwise reduced to a material form. And 4, the creator must be a qualified person, namely a resident of or domiciled in South Africa. As a born and bred South African, Zandile is a qualified person. In this instance, Zandile's work meets all the requirements. Zandile is concerned that he has not applied for copyright protection. However, his lawyer confirms that by meeting all of the criteria listed, copyright subsists automatically. Therefore, as the copyright owner, he has exclusive rights to reproduce, publish, and distribute his work. Armed with this information, Zandile can get the blogger to remove all instances of his work from her page.